Yes. That was a fire test. We hopefully won't have another one, at least not today.
My lord, we hope so. I was on the information that would be required to be inputted into any TVM in order to ensure that a appropriate boundary fare was issued to a particular customer. And I'd explained that it wasn't just the possession of a travel card that would need to be verified, but also the zones for which it was valid, which type of travel card it was, and of the period of validity of the travel card. And so, of course, what that means is that if there were website redesign along these lines, it's going to introduce, inevitably, some delay. And that will mean delay to other customers. And one does have to bear in mind who will also be trying to use these TVMs or the station counters as a means of purchasing a ticket. And one has to bear in mind that the travel card holding community are a minority. It's not now, I bandied around the figure of 1 in 20, or less than 1 in 20. Mr. Moses says, well, actually, if you look at Mr. Holt's figures, they show that 18% at the beginning of the period held travel cards going down to 12%. But the way I got to 1 in 20, and I confess it's just a very rough back of the envelope calculation, is you have to consider that not everybody who has a travel card is going to be travelling on a relevant journey. And that's something, if you look at Mr. Holt's table 6.4 and 6.5, he excludes millions of journeys where, for example, they are within the travel zone, or where the person would not have a travel card for the relevant zone to which they're travelling. So actually, when you think about the number of people who are using these TVMs to buy tickets, I say you're going to get down to something like it being relevant, potentially relevant to 1 in 20 people. So those designing these systems have to bear in mind, is it worthwhile introducing this for every customer, these kind of questions, when it's only 1 in 20 who can benefit? And when you then introduce a delay where they have to click through and input information on multiple screens. It's not and it's even more complicated on the website, because the website, as I think I mentioned in opening, has got is set up for use by virtue of the time of travel and not your ticket type. So it's very important that this court shouldn't proceed on the assumption that this is going to be, that this is somehow, there's some sort of magic wand where you can have a click of the switch and you can take the benefit of a travel card and get a cheap boundary fare. It can't work like that. And the facts show that it can't possibly work like that. And that has real implications, because it means that there will be an inconvenience factor when it comes to purchasing a travel card. Forgive me, not purchasing a boundary fare. So if I may then come back to against that background, to the general points. My learned friend started his submission by drawing attention to his draft amended claim form, in which the claimants have amended the language to emphasise that this is not a strict liability claim for all double charging, but instead it is one based upon an allegedly abusive failure to use best endeavours to make boundary fares more accessible and better promoted, above all better promoted. But then immediately having done so, my learned friend then went on, you'll recall, to describe the quantum of his claim and the number of claimants, and he asserted that there has been what he called overcharging on 90% of relevant journeys, and that all such claimants have a claim. And that, we say, only serves to illustrate the fallacy that is at the heart of the claimant's approach. Because one cannot reliably quantify a claim for failure to use best endeavours based upon the methodology that would be applicable to a claim for strict double charging. Unless the class member would actually have purchased a boundary fare in the counterfactual world in which there was better promotion, the class member in question has no claim. And we just don't know how many of the class members have a claim or not. And one can't just proceed on the assumption that they all do. Now, my learned friend repeatedly spoke of overcharging or double charging, but there is no claim here for unjust enrichment. This is a competition claim for damages, and there is no restitutionary remedy that is either sought or would be available in law. And it's a fundamental to any claim for damages that the burden is on the claimant positively to prove causation of loss. And what is required here is a methodology to prove that causation. Now, my learned friend Mr. Harris has dealt with the question of whether aggregate liability as well as aggregate damages are permissible under the Act, and we respectfully adopt his submissions on that point of law. But irrespective of the resolution of that aspect of this appeal, one thing must be clear beyond measure, and that is that even aggregate liability does not do away with the basic legal requirement of claimants in competition law damages claims to prove causation, at least in the aggregate. Now, my learned friend has wrongly characterized us as suggesting that there should be a mini-trial, or insisting that they should come up with all their evidence. We have never made that submission, nor do we say that my learned friend cannot assert his claim. Of course he can assert it, but he must also, in the context of a collective claim of this nature, under the process test, must put forward a plausible methodology. And we say that that entails a plausible methodology that is a complete methodology for all critical steps in the calculation. And one of those here must be causation and reliance. Now, my learned friend, Mr. Moser, took me gently to task for not referring to the cat's remark that the burden on the applicant under the process test is not an onerous one. We fully accept that. It is not an onerous one. But that only makes it all the more important that it should be satisfied. It is one of the few requirements that applicants bringing these collective actions must satisfy. Now, my learned friend's case really is that the reference to a potential survey by Mr. Holt in his evidence and his outline description of that, of what a survey might consist of, constitutes a process compliant methodology. And we respectfully disagree. And we disagree for two reasons. First of all, and this is the fundamental reason, Mr. Holt does not purport to say that that survey evidence will be a measure of the overall level of uptake in the counterfactual. At most, it is envisaged as a potential means of addressing some, and some only, of the specific examples given by the defendants as to why there would not be universal uptake in the counterfactual or why certain matters need to be accounted for. It's not a methodology to assess causation in the round. It's at best a methodology which takes as its starting point an unjustifiable assumption that there would be causation for all class members, and then looks at certain instances of why, not by no means all instances, of when the loss would not be caused, the demonstrable counterexamples. And it proposes then to extract those. And that approach, which we say was wrongly accepted by the tribunal, proceeds on this assumption that the applicant is entitled just to assume causation and reliance for all claimants, save in defined circumstances, proved and quantified, it seems, essentially by the defendants. And it's really based upon this one simplistic bit of rhetoric to the effect that, well, why wouldn't you make a small saving if you could? And we say that is incorrect as a matter of law, and also likely to be incorrect as a matter of fact, because common experience teaches us there are multiple examples, and there are multiple examples in the evidence of why claimants would not avail themselves of boundary fares, even in the counterfactual. To take an example, the case of customers who don't care sufficiently about price optimization, given the inconvenience that would inevitably be involved in purchasing a boundary fare, the time and inconvenience that would be involved in purchasing a boundary fare. Now, this is not something that I made up on my feet at all. It's the 7th example that's given in paragraph recited in paragraph 126 of the judgment. And the CAT recognised that this is a possibility. But then it says, very puzzlingly, in paragraph 131 of its judgment, says that it is a matter that could be established by Mr. Holt's survey. But with respect, Mr. Holt's survey was never designed to address that point. And that really is a case of the tribunal simply mentioning the word survey in lieu of insisting on a workable methodology rooted in the facts. We also say that, and I won't repeat myself, that it's wrong in law to take this approach, because one isn't entitled, the claimants are not entitled to help themselves to an assumption of causation of loss and then throw the burden back on the defendants to disprove it in particular instances. Now, the second reason why we say Mr. Holt's survey does not satisfy pro sis is that when one actually reads those pages of Mr. Holt's evidence in his reply report, there are two things to bear in mind. The first is that they're really just a description of the basic generic requirements of surveys in general. And Mr. Holtz clearly states at paragraph 3.6.4 of his reply report that he was not asked, and again, he was not asked, I make no criticism of him, not asked to specify a customer survey. And so far as we're aware, no survey expert has ever even been instructed. So it's hardly surprising then that the only meaningful detail on the actual survey envisaged is to identify topics for certain questions, but not the questions themselves. He doesn't explain how the answers to the survey could in practice be used to resolve the various points raised by the claimants. Now, it's obvious that the use of a survey at all to ascertain what people would have actually done in a counterfactual scenario is itself likely to be highly problematic. If you ask people, would you make a small saving if one was available, if it took you a small amount of time? Most people will say that they would, of course. But whether they actually would avail themselves of that small saving in the real world in which it was available is a very different matter. And experience teaches us that. So one sees from the uptake of things like loyalty cards and discounts. But more fundamentally, it can't be right to say that evidence from an economist about an unspecified future survey could suffice to pass the pro sis test. Suppose, for example, that an applicant for a CPO came forward seeking certification of a large class action, requiring for a central aspect of the calculation of loss, a complex economic analysis. The applicant submitted a witness statement, and the witness statement said, I will quantify my claim by, in the future, instructing an economist to do econometric analysis. And here I will set out in my report, in a few pages, some of the generic things that I understand econometric analysis should generally satisfy. And here are the topics I intend to ask him. In our submission, that would plainly be inadequate. What is required in our submission is an outline from the expert in question, here a survey expert, or at the very least, we say, a survey specification.
Are they entitled to await disclosure?
My lord, they're not, because one of the process requires that they should at least outline the specifics to some degree of the expert evidence that by which they are planning to quantify and establish the loss in our submission. And my learned friend adverted to the debates that have been had in other recent collective actions, such as Qualcomm. One needs only to read the nature of those debates to see the different nature. They are about the precise specifications of proposed econometric methodology on the two sides. We are simply miles away from that. There isn't any specification of the survey whatsoever because Mr. Holt was not asked to specify the survey. And we say, when you're dealing with a claim of this size, that's simply not good enough. My lords, my lady, those are my submissions in reply.
Thank you very much indeed, Mr. John.
My lord, my lady, I have no further reply, but my learned friend Mr Harris did raise two new points of US law, which I would like to have the indulgence of the court to address for literally 2 minutes, if I may.
Right.
I'll be as brief as I can. The first concerned Article 3 of the US Constitution. My learned friend pointed out in Authorities Bundle 4, page 1155, the bit in Azakol that I read out that said that Article 3 nevertheless precludes the use of a civil suit to make an award to an uninjured person, and said, well, that is all about standing. I respectfully differ from my learned friend on that point. If one goes back to the source of that citation, Tyson Foods, Chief Justice Roberts, that is at 1133 of the same bundle. And if one looks at 1133 of that bundle, what the Chief Justice of the United States says, it's just below the second hole punch, 1133, second sentence, or actually the third. The second sentence is a single word, perhaps, I think. Anyway, but Tyson's insistence on a lump sum jury award cannot overcome the limitations placed on the federal courts by the Constitution.
Sorry, where are we? What page?
We're on page 1133.
1133.
So in Azakol, they cite Chief Justice Roberts in Tyson. And if one traces that, that is at 1133. That's within Tyson. What the Chief Justice says is Article 3, 1, 2, 3, 4, 5 lines down, Article 3 does not give courts the power to order relief to any uninjured plaintiff, class action or not. So that it was a simple point, but it's not just about standing. Standing obviously is part of it. It's also about cause of action. And we say it's different under section 47C as interpreted, as explained. The other point of law is that my learned friend Mr Harris pointed to Azakol and said that I had cited not one authority to the contrary in relation to the outcome of Nexium and the outcome of Azakol. As a factual correction, I just want to point out I did cite Torres, and I said that Azakol failed to distinguish Torres. It is true I did not take your lordships to Torres, which my learned friend also didn't do, but just for your lordship's note, the relevant sections in Torres that illustrate the different approach taken by the Ninth Circuit as opposed to the First Circuit are in Bundle 4 at page 1114 in Torres. That is the proposition that there can be the presence of non-injured individuals, 1114, and 1118 in Torres, and that is the proposition that where aggregate damages are calculable, they may be all that plaintiffs need to prove. So that is the alternative approach in Torres that I urged upon the court. I admit unseen, but it's not right that there is no counterversion. So Lords, that's all I wanted to say.
Lord, my lady, I can't resist that Torres is in fact distinguished in Azakol directly contrary to the submission you've just heard on page 1157, and that's the line before the one that I cited, which said, in no case cited above, nor in any case to which the plaintiffs have direct attention has any federal court done the thing.
So where are you reading from?
1157, so right-hand column. So Torres preceded Azakol and is therefore referred to and distinguished in Azakol, halfway down the right-hand column. And then directly beneath that is the sentence which I read out before, which says, in any event, in no case cited above. And the case cited above is Torres, nor in any case to which a plaintiffs have directed their attention as a federal court affirmed a damages judgment, etc., etc. So that's not correct.
It's dealing with a different point, isn't it?
That is a different point. That's
That's
the
a different
point.
point. I mean, the point that you've just dealt with is a point. That point is a point about whether or not the defendant can challenge at trial somebody who hasn't suffered any injury.
My lord, yes. And also what I said about Torres in my original submissions.
It's whether the class can include non-injured members.
That's right. And in Torres it was found it could. In Asacol it was found it couldn't. And so they are different. What I did say about that passage, my learned friend quite rightly read, is I said it was dealt with by recital in Asacol, but not really distinguished. It purports to distinguish Torres, but it doesn't. It does so very weakly, and as my lord says, not really on point.
Well, it sort of makes the point, doesn't it? He makes the point, well, if it's just a few individual people who can be picked off, it's not really, it doesn't really sort of alter the position.
And on that basis, 47C can become irrelevant if, because it's only permissive anyway, setting that aside, the tribunal were to take the view that the vast majority of people had suffered some loss. It certified a class without differentiating between non-loss and loss. And it then found a way of winnowing out absolutely and possibly conservatively everybody who wouldn't suffer a loss at trial, so as to be absolutely certain that no individual who suffered no loss was recovering.
My lord, yes, well, if that's the whole point about the answer to common issues can be different. So it is possible for some of the claims to fail. That was the Vivendi point in Canada. So
But they may fail, for example, on breach. I mean, to take Mr. Harris's point, you could just include relatively generously people within the class, recognising that some may have suffered no loss. And then the methodology is found by the CAT to be satisfactory to preclude anybody, any individual who'd have suffered no loss from the class at trial and or from quantum, cover both. And I don't think that's an aggregated approach. That is an approach which precludes any individual who has no loss. I mean, there may be little difference in practice between aggregation and individualisation, but it results in the situation that the defendant does never compensate somebody who suffered no loss.
and that's exactly the situation I opened with. And said it's not going to happen here in any event because we have a different form of aggregate assessment.
But there are different ways of getting to the same result, whether through 47C2 or otherwise.
Yes.
Okay, all right, well, if you've all had your say, then that's the end of the hearing. Thank you all very much indeed for your extremely helpful submissions, and to all those behind you who I know worked very hard on the matter.
My lord, there is just the issue of the note. I don't know whether that is no longer required.
Sorry, I'm sorry, Mr.
The
Jarman.
note from the note on the position of the train operating companies.
Well, if we find that we can't finalise the judgment without having it, we'll let you know. But don't please spend time on it.
We're very grateful.
We will reserve judgment, obviously. You will get a draft in due course for identification of typographical errors and the like, not for inviting the court to reconsider points of substance. And if judgment will almost certainly be handed down remotely in the modern way, if you could please, so far as possible, agree an order before hand down. If you can't, then we will deal with it in writing. Yes, I think I should, given the number of people involved, remind the parties at this stage that when you receive it, and it's now, you will have seen the new rubric on the front, I hope, of Court of Appeal judgments, and indeed, I think of High Court judgments as well, certainly in this building, that reminds the parties of the confidentiality of the draft judgment. It's not to be shown to anybody who's not involved in the consideration of the issues in the case, and any breach of confidentiality is a contempt of court. Thank you very much.
Alright.